So under Article 3, we were learning about that if you are communicating anything through written medium, so when it would be considered as delivered. So in order to evaluate whether this should be considered or has been delivered, so we will be looking into some pointers. What are those? When it is delivered to the address personally, basically you are delivered to address the person who is going to receive this, delivered at the party's place of business or habitual address or mailing address. If the party's place of the business, habitual address or mailing address cannot be determined, in that case, written communication would be considered delivered. If it is delivered to the addressee's last known place of business, habitual address or mailing address, right? The communication is deemed received on the day it is delivered, right? But it should be ensured that the address you are sending at will be the correct one. The relevant court and authority is the one recorded in the country of the arbitration, right? So probably you will see one question coming from this paragraph. They will try to glitch you. They will try to, make you feeling stuck in the address. Will it consider as the latter to be delivered? Okay. So you have to be clear enough what are the possibilities are there and when the possibility. This is a hot possibility. If I just be very vocal about this. Okay, so just try to remember this as well. Otherwise, all three are seems to be not very hard to remember. Now the arbitration tribunals. So the number and procedure of selecting the member of tribunal can be decided by the parties. Now there is one more thing. When I was saying that when I was being very vocal about that, the arbitration are the person who basically look around the arbitration process. So the number and procedure, how many number will be there and what procedure will need to be followed. By the procedure, I mean that what are the important things to be taken care of, what are the not important things to be ignored. Okay, so this is something the parties can decide by themselves where they want their focus more on. Okay, so the number and procedure of selecting the member of the tribunal can be decided by the parties' consent. If the parties are unable to appoint arbitrators, so there will be 3 arbitrators. There was one question in your kit, probably in your ACCA over your ACCA study up, and this was a question in the one of the paper. So if the parties are unable to appoint the arbitrators, so there will be 3 arbitrators. Necessity won't be barrier to appointment of the tribunal unless the parties agree upon otherwise. So if the parties say that they want specifically this nationality, in that case, it would not be having issue. Otherwise, nationality would not be having a problem or would not be creating issue. If the parties can't agree on the process to appoint arbitrators, then both parties will appoint one arbitrator each, and these 2 arbitrators will assign are 3 arbitrators. So there is one more thing. Most of the time you will see there is a single judge. Okay. Then comes jury. Okay. Hello. In your arbitrators,
yes, sir.
it could be that one arbitrator is there. If the parties are unable to appoint, in that case, 3 arbitrators will be there. Okay. If the parties want to appoint the arbitrator by themselves, so they will appoint one arbitrator by themselves, and these 2 will appoint the one arbitrator. Okay. If the party or the 2 arbitrators fail to make necessary appointment within 30 days of being requested to do so by the other party, the relevant court or authority will make the necessary appointment. It does mean that now the court and authority will appoint the 3rd arbitrators, right? Challenging the appointment to the tribunal. So when there is an appointment, so there are certain rules that we have to take care of. About a party is convinced that an appointment to the tribunal could be partial, not independent, or unqualified as per the agreement. What does it mean? That party is convinced that an appointment to the tribunal could be partial, not independent, or unqualified as per the agreement. Siddhant, Samvit, there.
Yes.
Could you try this? The first one. Siddhant, would you please?
You want us to read, sir?
No, I want you to explain me what you have understood from the first statement, which is there. A party is convinced that an appointment to the tribunal could be partially. So the tribunal they're talking about, it is an arbitration tribunal. Okay, not independent or unqualified as per an agreement. Okay, so what they trying to
So they
convey
believe
through
it.
this?
Yeah, they believe that the uh, that a person who has been appointed as arbitrator by the tribunal or to the tribunal uh, is not independent. He's biasing or favoring one side, or he's unqualified and does not know, is not qualified enough to be an arbitrator in that situation.
So it does mean to convey that whatever the arbitrator will be there, it should not first be independent. It should be independent. Okay, it should not be that it is biased that you were saying. Second thing, it should not be unqualified as per the agreement. Okay, because whenever there is an agreement, suppose when you're going to fill a form, okay, any form when you're filling, so there will be some information which will already be given. Those are term and condition. So whenever there is an arbitration process which is going to take place, so there are some conditions who can be the arbitrators, right? Hana? That becomes a part of the agreement. So when you're going to appoint the arbitrators, so you have to ensure that you are appointing someone who is first of all independent. Second thing, who is eligible to become the arbitrator. Okay, arbitrator. Third thing that you have to look forward, it could possible that parties might take the support from the government as well. It does mean that they can appoint it partially, and they can say that they can, for example, they can appoint, or they can say altogether that we are not able to appoint, and the parties would be helping them. Okay, or they can take the help of the any government while appointment, but ultimately this is to ensure that the person who has been appointed as an arbitrator should be the one who is independent. Second thing, because independence, why it is required, because to ensure that the decision which will be there will be unbiased, right? And he should be the eligible to be one. Okay, understood? And this is to ensure that the appeal must be made to the tribunal within 15 days of being informed of the appointment. When you have made an appointment, so you have to make sure that you are informing the tribunal or the arbitration tribunal within the 15 days, where the arbitration process need to be started. If such a claim is rejected by the tribunal, the party can challenge the decisions in the relevant court within 30 days of the judgment. The decision of the relevant court shall be final and unchangeable. Unchangeable means there will be no appeal. Okay. So this is one of the disadvantages that you will see in the arbitration, that the appeal is not there. Okay. Major disadvantage. The tribunal will continue functioning when the relevant court is still deciding on the challenge. The party can request the removal of arbitration even if he has been appointed to the arbitration himself. Okay. Hello, guys. Understood?
Yes, sir.
Any doubt? Something you are unclear with? Hello.
No, sir.
If an arbitrator resigns, then a new arbitrator will be appointed using the same process as earlier. And what is that? The first process, that if the party enabled, then 3 are there. Otherwise, the party would be appointing one, and those 2 will appointing the other one. If those 2 fails to appoint another one, then the court and other concerned tribunal will be taking their charge. Okay. Is that okay?
Yes, sir.
Then we have to deal about the arbitration proceeding. So proceeding is basically the process when the arbitration process is started. Okay, so that is known as an arbitral proceeding, means when the case is ongoing. So appeal of improper jurisdiction. Jurisdiction is basically the country that is covered through the particular law. Okay, jurisdiction means the area that is being influenced by the law or by the court. Okay. Appeal of the improper jurisdiction of the tribunal must be made by the party before presenting the defense statement for the issue of the arbitration. Sometimes you will see it could possible that what happens that the case of, for example, there is in Delhi and there is in Gurgaon. Okay, so these are 2 different places. The case of Delhi probably be not going to register in the Gurgaon and vice versa, because the jurisdiction of both areas are different. Yes or no? If that happens, so there will be a conflict, or there will be a dispute, or there will be some issues, right? One party or the other party would be saying that if the case would have been written in the Delhi, so why it is there in the Gurgaon? Okay, because the jurisdiction, the people or the power, the governing power are different bit. Okay, the same goes with the High Court and other areas. Appeal. So basically, they are the two things that seems to be the simultaneous one. Appeal is basically what a person says in response to being charged with a crime, like guilty, not guilty. It happens at the same start of the cases. For example, suppose there was a party A, party B. Party A brings a case to the court of Delhi. So both of this party basically lives in Gurgaon. Okay. Now the party, basically the one who wants to claim something, he is a defendant, for an example, and party comes and register their case into the Delhi. Now in defense to that, P would be appeal that this case should have been written into the Gurgaon, not into the Delhi, because the jurisdiction area is different. Okay, understood? Both of you, please. Hello, can I have a confirmation or anything if you're not able to understand? An appeal is when someone asks higher. Okay, thanks. An appeal is when someone asks a higher court to review a decision made by the lower court, usually after the trial, if they believe something went wrong. After the trial means after the reward or the damages has been granted. If one party who need to be served justice feel that justice has not been served to them, in that case they can go to the higher court and appeal for that. Okay, so you should not be misunderstood between the two. Okay. Hello. If we talk about the arbitral proceeding in that case, so the first point seems clear to you, I guess. An appeal is an improper jurisdictions. Appeal of improper jurisdiction of the tribunal must be made by the party before presenting the defense statement. Defense statement is basically, so first thing is that appeal means they are saying that jurisdiction is wrong. Defense statement is that the claimant has provided something against, they are going to claim against the defendant, right? Now the defendant first statement, what they think about or what they say about the claimant is claiming, this is what the defendant is saying. So basically the first statement made by the defendant against what the claimant is claiming is known as a defense statement. Okay, so before the issuance of this defense statement, because defense statement would come after the start of the proceeding. Okay, so before this defense statement, if there is a jurisdiction which has been selected wrongly, so appeal should be made before that. Okay, is that okay? Appeal about the tribunal overstepping its jurisdiction must be made as soon as a specific incident takes place, right? Overstepping means the reference of the jurisdiction. Even if the party does not agree to certain procedures, the tribunal will carry on functioning as it seems fit. So each party is treated equally and has right to set the pace of the tribunal. What does it mean? It could possible that conflict would arise here. What does it mean? That some party might want some procedure to be followed and some party want that these procedures should not be followed, because the procedure what need to be followed or not to be followed is given or on the side of the both the parties, because this is just to promote them, what is important for them, what is not important for them. It could possible one thing is important for one party who want this procedure to be performed, other party do not want that procedure to be performed. This could be possible. If that happens, then court or the arbitrator will think itself whether this is an important procedure. If they think, then they will follow it, even though the other party who might say no to that. If one party is saying yes, other party would not be saying yes. And if arbitrators think that this is something the good procedure and should perform in order to bring the smoothness more on the side of the unbiasedness, in that case it can be performed. The parties can decide the language in which the arbitration will be conducted. If they cannot agree upon the language, the arbitrator will decide the language. Okay, all documents submitted to the tribunal and document used by the tribunal to reach the judgment shall be communicated to the all the parties. This is basically known as an evidence. Okay, evidence and working papers. So whatever the working paper of the court will be given to you. If any party failed to appear in the meeting or failed to provide documentary evidence, the tribunals, means arbitral tribunals, will function normally and announce judgment based on the available evidence. Unless, because this is something they do little faster. This is faster than court, so they have to form the decision quicker than. Unless otherwise agreed by the parties. If the parties are agreeing on something, it is okay. That will always prevail. If they are not agreeing, in that case, if the party fails to make a statement of the claim without proper reason, the tribunal will terminate the proceeding. So basically, the statement of the claim is going to be submitted by the claimant. Okay. Now, if the claimant is not able to provide the statement of the claim with proper reasoning, in that case, the tribunal, the arbitrator might terminate the proceeding. They might say that we will not be taking this case into the arbitral tribunal. Okay. Hello, understood? Guys, are you understanding even? Is there something that can help you apart from this?
Sir.
Both of you may have an acknowledgement prompt, please. Because I know this is something a weird one, and you might see other topic as well, but something you have to remember by yourself, because they are the keywords we can just learn and understand the concept, and this is that the best for some of the area I can give to you, because when you have to learn some of the area, because ultimately there won't be anything you can write by yourself. This is all about the MCQ based questions. So the key point is the key information, something you have to remember. Okay, when you will be having a practice or when you will be revising it constantly, it would be prompted and you will be feeling confident with the concept and the terms, or probably with the key information that I want to convey that you have to learn. Okay. Now we will learn about some of the arbitral award. Award means what is a resolution that will be resolution to dispute. Okay. So we will be learning about arbitration award is something resolution dispute. What is the feature of it? Okay. So it is a final decision by the arbitration tribunals. It is by the majority vote of the tribunals. If the party agree upon the settlement during the proceeding are concluded, or on the request of the parties, the tribunal could pass the agreed settlement as an arbitral award. So at the last, obviously, the arbitration would be passing their award, the resolution, whatever they want to think it isn't suitable. The award is in writing and signed by the all arbitrators. So they will be 3-1. Okay. So what are the rule for the correction of the arbitral law? Either party may seek correction within 13 days of award being announced. So it could possible that party might not be happy with the award. So they have a 30 days to appeal for it. Okay. If the tribunal consider the request justified, if they think the request which is made seems correct to them, it will make require correction within 13 days of receiving the request. So they again have a 30 days to make it correct. Additional award for the claim made during the arbitration can be made within 13 days of the award. If justified, the tribunal will make such award within the 16 days. An arbitration award may be relegated by the relevant court only if arbitration agreement was invalidated. So basically, what does it mean? When you go to the arbitration, like arbitration would not be having any appeal. It could possible that arbitration award might be cancelled by the court if the parties goes to the court after the arbitration. So whatever the award which has been given by the arbitration, if those goes to the court by the parties, and it could possible that court can cancel the award, and it is because of the following reason: arbitration agreement was invalid, the agreement which was there was already invalid. So obviously when the document are invalid, so whatever the decision which has been formed on them will be always cancelled out or relegated, right? The appealing party was not given due notice of the appointment of the arbitrations. The award is beyond the jurisdictions of the tribunals. So the tribunal or the arbitration tribunal, if they are giving the award which is beyond their jurisdiction, means their power, in that case, that will be cancelled out. The award is contrary to the public policy. Okay, so whatever the award you are giving, it should be into the public policy. If that is against the public policy, Contrary means something against. Okay. Now we will learn about something which is left. Other things you must know that unless otherwise agreed by the parties, the starting date of the proceeding is the date at which the request to refer the dispute to arbitration is received by the respondent. Okay. The parties would be setting the date from which they will be starting. Otherwise, in the case of the court will be the one who basically assign a date. But in the case of the arbitration, it will be on the parties to decide on. Can you able to see this is a little bit flexible, Hannah? Flexible than code? Hello? Guys?
Yes, sir.
Hello, guys. Can you able to see this is a little bit flexible than code, Hannah? Like the parties do have a right to define the procedure. They can decide the date from which to start. Hannah, a little bit flexible or something informal sort of. Now we will learn about the requisitions and enforcement. Okay. Under the Article 35, you do not need to remember the name of the article, but what do you remember that what is the exact statement or what is the exact convenience or what is the exact meaning or something permitted. So the article has given something to rule. They have a rule within it which they want to translate. So you have to remember the rule or the thing that they want to translate, even though if you don't remember the rule. They will not be asking you what is written in the article this and blah blah. They will not be asking you about that. They might give you something like this, and then you have to decide whether this is a true thing which is there in the Article 35 or not. They might present it a wrong statement, but you have to define whether this is a correct statement or not. So this could be the possibility. A question might come when you will see something like an article. They will not give you the statement under the Article 35 if this is something that no, this question, this type of the question would not be there. It could be there that if the article name is given, there will be some extra information which will also be given. If you do not remember something by the article, if you get able to answer by the statement, additional statement which is given the question, it would always be good and would not be having any problem. So regardless of which country the arbitrator award was made in, it will be recognized as binding. It does mean that we will not see where the arbitration award has been given. We will see if the arbitration has been given or if the court will not be cancelling this out. In that case, the award need to be given because it has been binding. If it has not been followed, in that case it would be giving the harsh consequences, right? Upon application, writing to the court shall be informed subject to the provision of the article. If you are going to after the arbitration, if you're going to the court, in that case you have to give the written acknowledgement, right, to the parties and other peoples. Under 36, recognitions or enforcement of arbitral award. Enforcement means something that becomes applicable. If you're not going to follow that, if you're not going to enforce it, you would, if you try to go against it, in that case it would be having a harsh consequences. Enforcement means something which is there already there, but if you're not going to follow that, it would be giving you something that will mean when you would not be following it, something more of the consequences. We can talk about that way. So if I say this, that under 36 article, recognitions and enforcement of an arbitral award respective of the country in which it was made may be refused only at the request of the party against whom it was invoked, and if the party furnished to the competent court where recognitions or enforcement is sought for the proof. So this is the area where you will be learning about. Allow me a minute. I think this. So this 5 point which you will be currently going to study, we'll be talking about the possibility when you have been given. First of all, this is a process when you have been given the award by the arbitration. Okay. Second thing you have to look after whether you are taking the arbitration award or not, whether you're going to the court. These are all other with other possibilities. What would happen after giving of the award by the arbitration is something going to be dealt over here. At the request of the party against whom it is invoked, if the party furnished to the competent court where the recognition or the enforcement is sought proof that a parties to the arbitration agreement referred to the Article 7 was under the some incapacities or said agreement is not valid under the law to which the parties have subjected it of failing an indication they've owned under the law of the country where the award was made. The party against whom the award is invoked. Invoked is basically one of the way of cancelling out. Okay. Was not given proper. I will be explaining this all 4 points. Just allow me some minute. I'm just trying to read and understand that because something that is coming new to me. The party against whom the award is invoked was not given proper notice of the appointment of the arbitrations of the arbitral proceeding or was otherwise unable to present his case. The award deal with a dispute not complained by or not falling within the terms of the submissions or arbitration. So this is something we will be discussing later on. I need a study on this area. Okay. Hello. I will be explaining this in the next class and then we will attempt some of the questions. This is something I will prepare a little simplest form summary to present it because ultimately this might be a little bit hard to understand from the which is given for you because ultimately what I can see something I have not been through this in Kaplan. Is that okay? Sure. So we will be covering this area as well tomorrow. This is something we can cover right now. So what are the advantages? You will see some of the question would be there in your paper where they will be talking about two things: the difference between the court and arbitration, and what are the advantages of the arbitration, what are the advantages of the court. These sort of the question would be there. A question might not come from this area, from here to below, but a question from this area will be there for sure. Okay. This is exactly what I mean to convey. Why you should choose the court at the place of arbitration. This is a hot question that you will probably be seeing. But ultimately, we can cover this area for now. So what are the advantages? It is speed. Generally, arbitration is faster than court. So whenever you are having a comparison, or when you can see that this is arbitration versus court. So the comparison is, or the advantage that we are going to study are against the court. So first is speed. Cost is also there. Costs of arbitration are generally lower than court. This could be primarily due to the pace of the process because of the speed or the time that is going to take is lesser than, so the cost comes out to be because of the time is going to be, there will be less hearings, there will be less procedure to be performed, there will be less appointment or less appeal by the arbitrators because ultimately you have to pay to the arbitrators, you have to pay for the time you're taking for the court, right, from the arbitration tribunals. So ultimately the cost will always be going to be reduced when you will see that the speed or when something is taking a lesser time. When I talk about the privacy, arbitration proceedings are held in a safe and private space acceptable to both parties, and unlike in a court, which could be the public. So this allows for the better privacy. And sometimes you will see that the major businesses always prefer to go to the arbitration because they have a major concern over their privacy. Because the fight between the major businesses are because of the copyright things, right? There might be some patent thing, there might be some new chemical, new drug that they have made. So the discussion about them, so privacy matters to them. So they basically always or prefer to choose the arbitration over the court. Okay. Then we have an informality. Exactly. They are less formal than a court and hence more flexible, something I've been vocal about, and they allow for more open and candid discussion. Okay. Expertise and arbitration tribunal specifically set up for a particular case. So they are for different nature of the cases that could come. So for every different nature of the case, there will be a different arbitration process would be there. Okay. The arbitrators could be people who are specialized and experienced in the matter being discussed. Okay. Neutrality. Arbitration can take place in neutral country where both parties would be more confident about the impartiality of the court. But it could possible that arbitration is also happening between the local two peoples, and that could be only within from the same country. It could also possible. If you talk about the advantage of the court versus arbitration, so judges are highly experienced expert of laws and can provide the better judgment. Court work on pre-established law and precedent. Okay, because they are different laws which are there. and pre-civilized laws which are there and present like previous decisions, and they basically follow them. Court basically follow them. Hence, generally, the judgment are more predictable. If you talk about this, there is more scope of appeal in the court, which is not there in your arbitration. So when I do say that these are the advantage of the arbitration, so can it mean that these are the disadvantage that you will see in your arbitration? Yes or no? And vice versa for this area. Okay. So with this area, we are done with this chapter as well. The last portion which is left, which is pending from my side, is something I will be covering in tomorrow's class, and I will get you through from this area. This is something that I haven't prepared yet. I was not able to prepare for this class. I will be preparing this and will present to you tomorrow, and with the summary as well. So this is something on me. Other than that, you have to read this and just try to attempt this quiz by yourself. Other than that, we are done with this area. Now, once we are done with this two area, the first and two, 1 and 2, we can attempt question from here to here. Okay. All right. This is from your BPP. Okay. Hello, guys there.
Yes, sir.
And for your Kaplan, what you can do, you can attempt question till here. 47. Okay. So you can either wait for me to complete this last paragraph tomorrow, and then we will have some other question from the Kaplan, and I will even see some question from the VPP, so that we will be having some of the question practice in the class as well, and then you can do the pending one. Is it okay? And I think it would be good if we take the BPP and Kaplan simultaneously and just focus on the ACCA study up at the later on. So I was thinking about it, and it would be good if we just keep the ACCA study up as the last one, just to completely revise after you're done with your second revision. For the timing, what I would be asking you, just to get yourself done with the revision or the things, just revise the things that we have done and just try to revise, and then we will be having a homework to attempt question from your Kaplan, 47 questions, and then till here for your BPP. Okay. So 2 chapters, Kaplan, 47, and BPP till here. This is something that we are done and that we can able to do. Now I will be attempting that portion tomorrow, and then we'll attempt some of the question and we'll transfer that work to you. Is it okay?
So we have to do first 2 chapters from Kaplan, and
So I'm talking
the
with
first
Samvit or Siddhant?
me, Siddhant.
Done. Yes, brother. Please.
So we have
Sid, you were
to
saying something?
complete the first. Yeah, so we have to complete the first 2 chapters from Kaplan, and those 3 chapters from BCC.
Could can I ask you one thing, please?
Yes, sir.
Just revise yourself from this text, okay? Just give it for once. Let's check this whether we can able to deal with every question which are coming or not. If we can able to deal with every question after reading through this, then we will not go to the Kaplan. We will not waste our time, okay? But if we feel that there is
So
some
right
issues,
now
then I will.
on our own No, I'm just saying on our own, what questions do you have to solve? Or do we just have to revise the content?
So just revise the question. Try this question by yourself. These 2 questions, okay? If you can able to. Otherwise, we will just start with that paragraph tomorrow, and then I will take some of the question from the Kaplan BPP as well tomorrow, and then I will transfer that work to you. But if you want today's homework, then I would be suggesting you just revise the first 2 chapters that we have done, okay? Then try to attempt some of the
Okay.
question from the Kaplan and BPP by yourself. If there is any doubt, I will help you out.
Okay.
Otherwise, we will see some of the question tomorrow. Okay?
Understood. Okay.
Can I have a confirmation? Like, have you understood the things? Have you acknowledged that there are certain things that you have to learn?
Yes, sir.
Okay. That paragraph that we are left with, which I was not able to prepare, I will be just presenting it tomorrow. Okay. Samvid, are you there? Would you like to speak
Yes,
to
sir.
me?
Yes.
So have you understood the things that we discussed today?
Yes.
So both of you will start reading the things from the text which I've presented. Okay, this just start your reading with this white label book, which I've already said to you. Just read the very first and two chapters and just attempt those cues which is there in the chapter and just attempt these questions yourself. You have to just give it a try. I will be discussing questions tomorrow. That is on me with the paragraph, but you can try by yourself. Okay, just try to know what is the issue that you're facing, so that we can come or just get on the nerves where you're having some issues earlier on in the process. Is that okay? Other than that, we are on the time.
Yes.
We are on the time, and I will be finishing up this in the very first week of the July. After that, you just need to practice, and I will be connected to you, both of you, through the WhatsApp group, even through the call. If you want extra class, I will provide you. Okay, but just to cover on the syllabus, I will be finishing up the lectures in the very first week of the July. Okay, but other than that, you will be having access to me through the call, through WhatsApp, through even if you want extra class, I will be presenting it. Okay, and this paper can be done in 40 to 45 days. Okay, so do not delay it, please, both of you. Okay, do you acknowledge it?
Okay, sir.
Yes, sir.
Done. Anything else that I can help you with, brother, both of you?
That'll be it.
Samvit?
No.
All right. चलो ठीक है फिर, have a good time. Bye bye. Thank you.